Your Honor, Gall versus Gall, I'm requesting a continuance as well. I wasn't given a chance by opposing counsel to respond.
Aaron
Okay.
Winkles appearing on behalf of Jesse Gall.
All right. Go ahead, Mr. Gall.
Yes, sir. I'm sorry. Yes, ma'am. I was served on the 20th of December when the other party knew I was out of town. Obviously, this is perfectly timed for their portion, but I just haven't had a chance to respond and give the court my side of the story so that the court can make a proper decision, Your Honor. And all I need is until the first week of January so that attorney can continue with her request.
So you're asking for 1 week to next Tuesday?
Yes, that's correct, Your Honor.
All right. Ms. Winkles?
You know what? If it's only 1 week, I'm absolutely fine with that.
Thank you, counsel.
All right. So, this is my last docket of this matter, of this nature, I guess, on any reoccurring basis. I'm just going to give a heads up to the parties about a GAL, and I don't know if a GAL is something that's been considered, but it's interesting that there isn't one.
There was one. It was she was appointed in the protection order because that's where this case, which was originally signed, was the parenting plan was even under the protection order. Yeah.
Okay. Perfect. I just didn't see it under here. All right. So we will set the matter of Gall and Gall, which is over 1 week, to January 2nd at 1:00 p.m.
And Your Honor, I can still file by the end of tomorrow, correct? Before for the court to have by the 2nd?
You should be able to do that, yes. And what I would encourage, if you are concerned that the judge won't have, that it won't get into our computer system, you can always file an extra bench copy and have that directed to the judge for review.
An extra bench copy. Thank you, Your Honor. Appreciate
No problem. So January 2nd at 1 p.m. All right. And I did receive the declaration from Miss Jocelyn. Miss Baldwin.
Thank you. So in this matter, we've already waited for 3 weeks for the hearing today. My client does want to move forward. The concerns here are that there's a very clear adequate cause. We have 2 restraining orders that have been entered within the last year against the petitioner. And then my client details the violence in the mother's home, domestic violence, with direct screenshots associated with that, domestic violence in the home, putting the child at really direct risk. Similarly, child witnessing this behavior, witnessing the behavior that resulted in the restraining orders, significant instability on the part of the petitioner, and just kind of glazing over the surface of those arguments. There is a reason in this case to go forward and protect this child. What we would recommend, instead of just straight continuing it, is instead based on the materials provided, is to grant adequate cause, to adopt our order as an interim order, and not to deal with child support at this time, and to set it over only for the purposes of entry of a full temporary order. Both sides can then argue what that temporary should look like, appoint a guardian ad litem, but that we should take steps to protect this child now, given some of the very concerning aspects regarding domestic violence in that household, and the 2 restraining orders that were taken out and entered by the court against the petitioner. And this is a case where the child's at risk by waiting. We've already waited 3 weeks. Waiting 6 weeks just isn't reasonable. Putting the child at risk for another week isn't reasonable.
Okay, Ms. Winkles. Thank you.
Yes, Your Honor. The fact is that they've waited almost a year. And the reason I say this is because there have been a number of opportunities, if they were really concerned about this, to do it at the time of the first protection order, at the time of the second protection order. There have been so many opportunities to bring up this issue that to then wait and say, we're going to give you the 3 weeks, but there's no counsel in Cowlitz County that are taking new cases. So the counsel that took this case, who I'm stepping in for, Jennifer Jocelyn, is in Clark County now at my office, came in on the 20th. So to grant adequate cause without any sort of ability to defend oneself when we don't know if there is adequate cause, it's strategic. And the problem is that this should have been dealt with in any of those protection orders if there was an issue. Why were those protection orders updated and amended, but nothing was referenced about mom? it makes sense. My client, Miss Jocelyn is not asking for a significant set over. She's asking for 2 weeks. The child in the last 3 weeks, there have been no police reports. There have been no issues. There have been, the child's safety has not been an issue in the last 3 weeks. To have another 2 weeks when the child's been in the mom's home repeatedly over the last year without incident seems to be a problem. Additionally, it needs to be noted that he filed for modification in October. And court for that was in March, and it was not brought up at that time. So why is that? And why are we doing it now? It seems strategic. It's right around Christmas time. It's right after the holidays. There are no attorneys. So, Your Honor, I would ask for an extension for Ms. Jocelyn, and I know nothing about this case minus what I just read about 5 minutes ago. Allow Ms. Jocelyn the ability to get a declaration from her client, again, hired immediately before Christmas. 2 weeks is sufficient as long as she's given a week to get that declaration. We can make it shorter, but I'm not sure how that would be possible unless there was no reply or the reply was due only a day before.
What parenting plan are we currently operating under? Because I'm looking, excuse me, and I see one from April 12th, 2023. Is that the only plan that's in place?
There's one in March.
Yes.
And yes, so there's one in early spring 2023. So it's a 50-50 plan currently.
And that was the modification that was done in October. And
so the parties always had a 50-50 plan. The modification was a minor mod to, they had a sort of a pro se 50-50 plan with lots of loosey-goosey language. The initial minor mod was to set some really firm boundaries, and that's what the spring 2023 plan did. It didn't create a 50-50 plan. It just sort of made things really clear about who was to transfer and when.
All right.
And at that time, just so Your Honor's aware, he requested the 50-50 plan continue. But when you look at the declaration now, we go well into the past. We're not just talking about March and forward. And yet in March, he requested as well the 50-50 plan continue because he was the one that filed that.
The restraining orders all happened subsequently.
But some of the issues involved appear to be before March. And again, I know very little of this case. She's in the adoption docket.
So I was able to read most of this, not all of this. Not everything got into Odyssey before I was out of the office last week. I had a little bit of time after my docket this morning before today, and I had bench copies waiting for me. I was able to go through a lot of it, not all of it. And I saw the declaration. I do understand that there is a shortage of attorneys, and especially at this time of year, that can be difficult.
I've not read the declarations, so I would have absolutely no ability to argue this whatsoever. I just stepped in for continuance because she's on another
The
docket.
declaration I'm referring to is your Miss Jocelyn's declaration for continuance.
I haven't read that either.
And I understand the concern. I can't say with certainty, based on some of this information, there is question about dates and how old or new some of these allegations are. There's a lot of photographs that were provided of concerning images of the child, but no, I don't have dates for when that was. Obviously I have concerns, but I do think it's appropriate to allow time to respond. If it took time to get Miss Jocelyn on board, I can definitely understand that. So I'll probably do something that makes nobody happy. I'm going to give a continuance, but it's only going to be until the 2nd. There's enough information in the information that has been received by the court that I think it does need to be addressed sooner rather than later. And so we'll set this over 1 week to the 2nd. I'm assuming based on that, the responses can be late from Miss Jocelyn, and those can be served as bench copies to the court in whatever manner she feels is appropriate. And I'll just make sure the next judicial officer is aware of that. Because of the timing, but I think we need to address it sooner than later.
Can we make her response due Thursday by like midnight if she's just e-serving it? That gives me a single day to essentially get out a reply because Monday is a holiday.
Oh, I think that will be fine.
Let's shoot for that.
Okay.
Thursday by midnight.
And I appreciate, I know I'm putting everybody under the wire there with that order, but I think resolution quicker than not is appropriate given the allegations.
Okay. Thank you, Your Honor.
Your Honor.
Very good.
Thank you.
Petitioner Justin Kent.
I'm Brandy Jeffers on behalf of the respondent, Mrs. Kent.
And Casey Looney on behalf of the state for child support, Your Honor.
Good afternoon, everyone.
Good afternoon.
All right, so I spoke with Judge Scudder and Jaylyn, and I have another proposal for you to see if this works with calendars. My understanding was that the parties weren't available on the 12th of next week.
Correct.
Nope, I guess that'd be 2 weeks from now. So we have availability at this point for the 3rd, 4th, and 5th, and the afternoon of the 10th, all with the same judicial officer judge. So it'd be 3.5 days, not full 4. That is what's available at this point instead of the 12th. So I don't know if you need a moment to discuss or
I don't need a moment, Your Honor. I'm not going to be available then. So at this point, I mean, I guess we either bifurcate out the property, start there, so we will require less dates in the future, or we get back on the docket to set new trial dates.
Ms. Gilmore.
And I would say the opposite. If anything, we should bifurcate the parenting plan first. We're looking at best interest of the kids, and there's a GAL report that was recommending a transfer of custody last year, and the ruling was deferred because we were set for court in May. So if anything, if we're going to bifurcate, I'd ask that it be the parenting plan first. I expressed the same concerns I did in my client's declaration, just judicial economy and costs. But I guess I just don't know the availability, how far we're looking at if we set this out again.
Well, I don't know the answer to that either. We have we're confident it's going to take a full 4 days.
Yeah.
And Ms. Gilmore, you agree with that?
I mean, the issue is particularly pertaining to respondents' witness list. We have 17 witnesses. I've never called 25 witnesses in a family law case. So I would expect that likely would be the issue. I do think the majority of it is the parenting plan, but I do think that we could potentially get the parenting plan done in 3 days if we did proceed with the parenting plan next week. The home is on the market, so I do think that some of that time-sensitive nature is being addressed with the property. I think that the priority, like I said, is the parenting plan if we do bifurcate.
And how much time do the parties think would be needed for each portion? So for the parenting plan side and the financial side?
Say equal.
So 2 days for each?
Yes. And I would object to going forward with the parenting plan first, just because there's no motion.
Well, the motion is to bifurcate. The question is what are we bifurcating? And so again, my perspective is I think that 99% of mother's witnesses are pertaining to the parenting plan. So I was thinking that particularly 3 days for the parenting plan and a day for the property. This is a 6-year marriage, so.
If we set the if there was I guess, Ms. Gilmore, what is your position? Initially, you were objecting to the bifurcation, but with not knowing if we can get 4 days in a row anytime in the at least really near future, is there other than your request to have parenting plan before finances, is there any other position that you or your client have?
Main concern is the costs, preparing 2 trials and not knowing second half will be, is going to be difficult. My client's priority though is the parenting plan and getting a residential schedule that's in the best interest of the kids. But I still have the same concerns, like I indicated in my declaration, judicial economy, getting the same judge on both issues, and then basically pre-preparing for both cases. But if anything, if we are pushing to proceed, my client would like to address the meat of the case, which would be the parenting plan.
And I guess that is an issue to address, Your Honor. Is there any guarantee of the same judge?
I mean, it can always be requested. Whomever is hearing it, there can be a request for them to be pre-assigned to the remainder of the case. Here's my only concern. Every single time I've ever done a bifurcation, it never works out because something inevitably bleeds over to the other side of the case, and we end up having to start all over again. That's happened to me on at least 3 separate occasions where I was the trial judge assigned to a portion of a trial, and so I'm hesitant to do that. I do understand this is a 2020 case. I see that it looks like they were married in 2014. So 6-ish year marriage, 6-7 year marriage. Do see that there's 2 children. This has been going on for quite some time. I would like to provide resolution. And frankly, if 4 days is kind of a hard set for everyone, it may be best to bifurcate. And I, frankly, historically speaking, finances going first generally isn't a good idea because there's inevitably something that is missed or overlooked or is relevant to the other side of things.
In that case, Your Honor, we will withdraw our motion to bifurcate and ask to be put back on the trial setting docket.
If I guess if you want to do that, that's great. Otherwise, my ruling was going to be to put forward the parenting plan and set it for next week, and set that for, I don't know if everybody agrees 2 days, and then hope for a pre-assignment and to get the second 2 days set sometime in the near future. That by way of either working with the judicial officer that's assigned for next week or by doing exactly what Ms. Jeffers just suggested. So
I'll withdraw the motion. Let's get it back on the trial setting docket.
Ms. Gilmore,
I'm somewhat frustrated. I mean, my client wants to have the case heard. We responded to the motion. I'll have to defer to the court. I understand the procedure of withdrawing a motion, but we're basically withdrawing it because she's not getting what she wants, which I guess that's up to the court, but I would ask the court to reserve on fees at the very least.
I'll allow Ms. Jeffers can withdraw the motion, so that's fine. We'll withdraw the motion. We won't make any determinations today unless you would like me to set it back onto a trial assignment docket today. I'm happy to do that, and I will reserve on any request for fees.
Yes, please. If you can put us on the trial assignment docket ASAP, I'd appreciate that.
Yes, Your Honor, agreed.
Miss Maxey, can we put them on for tomorrow afternoon?
Yes, I will let the clerk know that we'll need an amended docket.
Does that work for everybody to be on tomorrow afternoon? Otherwise, it'll be January 3rd.
Yeah, that's fine, Your Honor. Is that going to be 1 o'clock?
Yes, the 27th at 1 p.m.
That will work. Thank you, Your Honor. Thank you, counsel.
Your Honor, may I please check to just make sure it's not closed yet? I mean,
Oh, sure. Yeah.
Sorry.
Ms. Jeffers, if you could just wait.
That's fine.
Sorry. I don't want to frustrate things even more if that docket isn't available.
I apologize.
That's okay, Kaylee. I appreciate you checking.
It's still open, so tomorrow at 1 o'clock?
Yes.
Perfect, I got it down. Thank you.
All right,
Thank
perfect.
you.
Thank you, Ms. Sheffers. Thank you, Ms. Gilmore. And looks like we have Ms. Tangent and Mr. Hess. Mr. Hess, I wanted to ensure that you were served. It appears that you have been served, and I see that there is a declaration that you filed. And Ms. Tangent, did you receive a copy of the declaration as well?
Yes, Your Honor, I did. I received it at the end of the day last Thursday, so the 21st. However, with there only being one business day, on Friday the following day, because with the holidays coming up, I did not have time to reply and file it and give notice.
All right. Are you wanting to do that before the court hears the matter?
Yes, I put together a response. It's not very long, but I would like to read that to you.
Well, I can't, I mean, you can make an argument, if it's something that would be in a reply declaration that should be served on the other party before, and he should have an opportunity to know what's going on before we move on. So I can either set it over 1 week and you can file that and serve it upon Mr. Hess so he knows what you're referring to. Or we can move forward today and you can just make any argument you want.
Yeah, we'll just do that because I can't keep taking time off work.
Okay. All right. So I've reviewed your motion in order to show cause. And if is there any other information that you want to let me know about or argue at this point?
So the numbers have changed a little bit because when I originally filed this was not for contempt of childcare arrears. This was for the non-payment because we went to court in October, and that's when the new child support amount was set. And then he stopped paying in October, and that's why I filed the contempt. But since then, the numbers have changed a little. He's made a few payments since then, but there's still an outstanding balance. And still not doing it in a one-time payment on the 1st of every month. It's all over the place.
Okay, so the motion in order to show cause was filed after the new order of support was entered on October 11th. And that does indicate that starting on October of 2023, they would be a payment on the 1st of the month of $509. Is that your understanding of that?
Yes, Your Honor.
Okay, I just want to make sure that we're all on the same page. And was there it looks like on that order, and I don't know that it's directly addressed, it says that each party will pay a proportional share of work or education related daycare. So, and I know that that was part of, that's in your motion, and it may not be exactly what you're asking for the contempt for, but I just wanted to, so, okay. How much, so as of when you filed the motion in order to show cause, it appeared that, at that point, you said no payments had been made since September. So that would be September, October, November, and it was filed in November. So 3 months of non-payment. Now you're indicating that some payments have been made since the contempt was filed?
Yes, Your Honor. I believe maybe that is read. So basically what happened, so he did pay in September. So October, when we went to court and they increased the child support amount, in October, I did not receive a payment at all. I had to file contempt papers at the time he had an attorney. After I tried to reach out to him and said, hey, I haven't received a payment in over a month, plus there's an outstanding balance of childcare that is has been due for, well, it's been added to the case for about 8 months now. They've had a really hard time getting him to make any attempts on the payments. And so Then November, he made a $600 payment. And how my child care worker told me about that, the caseworker, she indicated that they take for the current. So when he paid 600 in November, 509 goes towards November's child support. So that's paid in full, and 91 went towards the balance of October's. Then in December, he made another, but then again, it's kind of all over the place and still not in the one time or on a specific day. He made another $600 child support payment. And so again, they counted that 509 towards December's to be in full, added the 91 towards October. Still have, like I said, the balance with the childcare. And then I just got to my knowledge this morning, after calling the child support line. I guess he on December 22nd, so last Friday, he it says there's 2 payments waiting to be processed, one for 200, one for 50. But when I talked to the child support worker's assistant today, because I think she was busy, when she replied, she indicated it's still over $700.
$700 in arrears?
Yes.
Okay, so that would be part of October and then whatever happened pre-September.
Yes, because originally in our parenting plan years ago, when you guys went in October and adjusted the child support, everything we got told was stays the same. So the other portion of that is the child care, because he was supposed to be paying for the last 8 years his portion of daycare expenses. That's in our first order. They said that it ties over into the second one, and he's never once paid daycare expenses.
And how do you give him notice of what that cost is?
Our child support worker, and there has been times where I've let him know on the phone. There's been texts that my son goes to daycare, who to contact, as far as to where he can make his payments, because it's supposed to be made to the child care center. I just touched base with my child care because I work full time, and they have never received a payment from him. And I have the print offs for the last 8 years.
Okay, but your contempt today is for child support. Is that correct?
It's for the child support and arrears. Yeah. I guess that's.
And that 568.86 is what the non-paid daycare expenses are at this point?
Yes, Your Honor.
Okay. All right.
It's
thank
actually
you.
$586.68.
I have 86.68. Okay.
Oh, maybe it is 68. Sorry.
Okay. I appreciate you answering those questions. Mr. Hess, if you could unmute. Good afternoon.
Good afternoon, Your Honor.
I did receive your declaration affidavit and I was able to review that. Is there, I'd like to hear from you of anything that you'd like to let me know.
I have actually never been contacted until recently about the child care portion whatsoever. When that was initially put in, it was explained that those costs were to be submitted to the state, and the state would add that into my monthly child support. That has never been done whatsoever. Ms. Tangen has been informed of my financial situation due to my injuries and such since March, and had actually said that she was never even going to go in for a modification and was happy with the $400 a month she was getting. So all of this has happened knowing that I do not have money and that I'm struggling on a daily basis just to make ends meet. And I have done everything in my power to continue to make payments. I was gone in October. I received a form in the mail, which I tried to find, but I currently do not have, but from the Division of Child Support saying they were going to be garnishing the child support from my disability. When I got back from dealing with my father's stuff, I called them because I had received a voicemail from our caseworker, talked to her, and then she had informed me that because it was not retirement and that it was disability, they would not be garnishing it. So that is when I started going to the SAW website and submitting the payments myself. And even, which I had already done there in November, but due to a holiday, it did not go through until the 16th, I believe. And then in December, I was able to submit it on the 1st, but it still does not process until the 6th. So I do not get paid until the 1st. And I try everything in my power to get this done in a timely manner. But I also have to ensure that my family is provided for. I've provided documentation showing the payment history, that I've never missed a month at all, even since being out of work. And that was the first one. And justifications for such. I really do not feel that having to pay tax on any of this is very tasteful in the situation. But that's my current situation with things. I'm doing everything I can.
All right, I appreciate that. Can I ask you a few questions? First, and I want to address this. I do. I'm sorry about the loss of your father. That I am sure is immensely difficult, and that always puts a hitch in things. You indicated on just now, and then in your declaration about the notice for the daycare expenses, and I know that isn't necessarily a specific allegation, it's just sort of an aside in the motion for contempt. Would your say, and it does appears to me that it was ordered your proportional share of daycare expenses. So is there a way for that? Is your preference let me start over. Would your preference be to have that be in one payment every month, or that parsed out and done separately based on the need and the amounts?
I was always under the assumption that whatever the need and amounts were would be added into my monthly child's support. So if it was $30, I would, my next bill would be $539, and I would be able to provide that. Whether it's added in or a separate one that shows up and I get notification of, either or is fine by me. It's just when it goes for 8 years and then knowing that I'm in a financial hardship, then it's all thrown at me at once. It's extremely difficult to even attempt to try to come up with that.
Okay. And I guess Ms. Tangent, is the child support average the same month to month, or does it vary based on extracurricular activities, work schedules, or is it kind of the same on a regular basis?
The payment is the same every month. It does not change, Your Honor.
Okay, and what is that payment?
So I pay $90 a month. And obviously, that's for 2 children. Obviously, he's only responsible for one. So I believe
$45.
Yeah, it's 45, but it's
he's portion of $45.
Yeah, he's only due for not the full 45, just his portion of it, of the 45. And Your Honor, I'd like to add one more thing.
Sure, go ahead.
So this ongoing, the childcare and the payments being all over the place during the month and nothing being ever easy. I do want to bring up that we did have an old childcare worker, Josh Bixler, who is now, Sarah Phillips is now the current. Josh is the one that started the process with me after he realized that Mr. Hess was not making the payments to the daycare center. Once that got brought to my attention, Division of Child Support had me fill out those forms. And they tried to send emails, documentation. They tried to serve him with notice of, this is the debt we've added to your case, and explain to him why. They tried to do that for 8 months and they got nowhere.
That's because nobody served me until all the way up into September. Nobody came to my house with any of it or anything.
Your
I was
Honor,
never served.
just like to state that he received numerous voicemails, asked to please return. Division of Child Support sent him numerous things in the mail asking to be returned, voicemails, and they tried for over 8 months.
Okay,
And-
so here's where we're at. In order to find a contempt, the court has to feel confident that there is a willful and an intentional violation of a direct court order. So that's what the parameters we're working under here. I'm in doing the math, $45 a month, and I have a 60-40 split as far as the proportional share, 60 to Mr. Hess, 40 to Ms. Tangent. So that would be my math, which I wouldn't feel offended if anybody double checked, would be $24 a month. That would be Mr. Hess's responsibility of that 45. I think the ideal situation would be if the 509 a month becomes 523 a month, and then there's no issues. If there's a way that needs to happen so it's recorded appropriately, then I would ask both parties to participate in getting whatever paperwork or calling whomever back to do what they need to do to make that happen. Clearly, there are some arrears, and I understand Mr. Hess's response to there being insufficient notice for that. It sounds as though the expenses have been relatively stationary and consistent for some time. And I do note the child, I think, is 10 or 11 years old at this point. And I apologize that I don't see the age specifically. So, given all the circumstances surrounding Mr. Hess, he also did provide in his declaration a debt calculation sheet, which clearly there's been a significant amount of debt for a period of time, but he also has been very consistent after, it looks like, once we got into 2019, we've had some really consistent payments, and it really isn't until October of 2023 where we have our first non-payment. So I have from November of 2019 all the way to October 2023 where every payment was done on time, according to, and this is the debt calculation sheet that the Washington State Division of Child Support authors and sends in. So I appreciate that being there. Based on that information and all the circumstances that Mr. Hess has recently dealt with, I don't know that I can find that it was a willful and an intentional violation. I do understand the frustration. My hope is there can be some work together to help on arrears. There are some arrears there, Mr. Hess, based on that, your proportional share of the daycare. But in looking at that, I mean, it's under $600. So to maintain that and catch up on that, I think hopefully is doable without too much difficulty moving forward. But I don't think I can find an intentional and willful violation of the court order. especially when we have overpayments essentially for November and December. And my calculations would show that those two $91 overpayments from November and December plus the additional $250 puts him at just shy of what he would owe for October. So granted, we're still dealing with some arrears from the other things. I'm not making a finding of a willful and intentional violation of the court order.
So can I ask a question, Your Honor?
Of course you can.
One of the reasons as to why I brought up the contempt is because the fact after talking with the child support worker and like learning like how kind of like all this works in the courts, I got told it would be in my good intention to bring this to the court's attention because of the fact, granted, he was doing great with payments for a long time, like you said, because they were being taken out like from when he was working. However, I have the original court order that the judge signed, was that 8 years ago, stated that it needed to be in a one-time payment on the first of every month. In the 8 years that this has been in effect, I have never been paid what I'm supposed to be paid on the date that the judge said. So the courthouse is actually who told me it's contempt.
And I think in the white letter reading of the law, it probably is a contempt because even the most recent court ordered support was monthly child support must be paid starting October 2023 in one payment each month by the first day of the month. So I get that, and I get the frustration if that order, which likely matches the historical orders. So I mean, the fact that you filed a contempt is on record. It's shown, Mr. Hess, you are technically, if this continues to happen, Ms. Tangent could very well file more contempts. You could be found in contempt for not following that court order. And I understand your needs for your current family. This is a court order and it is what it is. If the two of you can work together and we can do an adjustment to the 5th of every month, if that allows for time for the payment and to sort the finances and make a payment on the 5th of the month, I don't know that you necessarily have to work through the court to do that if you can get an agreement with child support registry, but maybe that's something you should consider.
Your Honor, may I say something?
Sure.
I was under the assumption from the very beginning that the first of the month meant I needed to be current by the first of the following month. That's even how, like for tax purposes, that's how it reads, is that I have to be current by the 31st of January or prior to the 1st of February to be able to claim him on my taxes. When I'm working, they pull it from my paychecks. That's why Ms. Tangen has never received a payment on the 1st of every month, because even the state pulls it from paychecks and then processes it and puts it through. So it's virtually impossible, even if I get back to work and everything, that she would receive a payment on the 1st of every month for that month. It would mean that I would have to have the payment processed prior to by a week or two for that to even happen.
So if you're garnished, the date isn't really, that part kind of isn't as significant. But at least the most recent order for support directly says in one payment each month by the first day of the month. So that's what the court order says. If it's a garnishment, I highly doubt if the state's garnishing it and it's coming through that avenue. Ms. Tangent knows that the support's coming. So she's likely, and I don't know, Ms. Tangent is free to do whatever she needs to do, but my assumption would be that in a garnishment situation, she's not going to file a contempt because she knows the money's coming, and that it'll come kind of consistently, even though it may not be the first of the month. The order specifically says first of the month, and even the past order says that it's due on the first of the month. If you need that to be something different, then by all means, you can make a motion to the court to have that addressed. But that's how I read it, is that it needs to be paid on the first of the month. If the two of you agree to the third, the fifth, and that there won't be contempts based on that, then that's what the two of you decide to do. But as for today's purposes, I'm not finding a contempt, but I am giving you notice that Mr. Hess, that that's what the order says. That's what you're required to do. And you also are required that proportional share of daycare. So hopefully moving forward, the two of you can sort this out.
Your Honor, so that way there is no confusion between me and him. So that way, with the childcare that you said, so what was the number? His portion of the 45.
Oh, I did it at $24 is what my math.
Yeah. Which I'm sure you're correct. I don't have a calculator in front of me. But I was wondering, so based on, as long as I'm receiving, because obviously, like I said, I filed contempt because I stopped getting child support, and it was a long time before I got one. As long as the child support is going to be made. But my question is, so that way it might make it a little bit easier for the both of us, is in our order, the last one that was signed, it states that he is supposed to make the daycare payment directly to the facility.
It does, yes.
I would actually like that way. Neither one of us has to file papers or anything. Leave the child support at what it's at when it's due. And if he could make that $24 payment to, I have the lady, the center's name, the fax number, the provider number of who he can make payments to, that would be very much easier.
No.
And Mr. Hess, are you agreeable to make the payment straight to the facility if she provides you the contact information for them?
No, I would much rather it be collected through the state, because then there is no chance of receipts being lost or anything of that nature, and the state actually has a record that it is being paid.
All right, then you need to take the steps to ensure that's happening. Otherwise, she can continue to file contempts if you don't pay those fees.
Okay.
Okay.
Yep. Thank you, Your Honor.
All right.
Thank
Good
you.
luck to you both. And
Yeah,
I see,
here, Your Honor.
thank you, Mr. Miller. I appreciate that. Miss Amiskita, welcome back. All right, so we set this over 1 week because you weren't here last week, Mr. Miller, and I understand it was kind of a long out review. And I've reviewed a few things. And Miss Amiskita, can you just unmute so I can make sure that you're hearing us and are there?
Yeah.
Perfect. Okay. Just no, it's okay. I've had that happen before where someone stayed on mute and then they didn't hear everything I said. I did receive a last minute response from Mr. Miller, and it was looks like his grandparents. And then there was another statement, but I'm going to show you kind of what I received.
Yeah, I couldn't read it.
Yeah, I can't. It's so light,
yeah.
I can't read it. So I don't know whom it even is from, what it's talking about. I did read the other one. Here's where we're at. So I reviewed all your protection orders. I reviewed everything that's going on. So the protection orders that in regards to Mr. Miller and the protection order in regards to Miss Amiskita's partner are gone and over with. I didn't notice that there were any requests to re-up either of those. And then we have Miss Amiskita's protection order is up on the 6th of March, 2024. At this point, in the very brief conversation that I had with Miss Amiskita last week, she indicated that she has not taken any steps at this point to try to change that protection order. When I reviewed that protection order, it does not have a carve out or a caveat for I have to switch screens here. So just give me a second while I move things around. It doesn't have an allowance in that protection order to allow for family law to trump that order.
Okay.
So basically what that means is if I were to enter a parenting plan today, and Miss Amaskita is around the wrong people, that are like the people that are protected, there still could be a violation of the protection order because that protection order is still in place at least until March 6th.
Okay.
So, and I understand that, well, I've expressed to both of you on multiple occasions my frustration that we got to a trial setting before a lot of things happened.
Right.
So this case has kind of been drawn out a lot longer than I would otherwise hope, and I'm sure than that both of you hoped. I'm pulling up that protection order just so I can look at it again while I'm
I did want to bring one thing up when you're done.
Of course. So the protection order, hold on, was entered on March 6th and it's good until March 6th, 2024.
Okay.
Here's kind of where, so there's two things that could happen. The first thing is, my thought was because that order is what it is, and I don't have the authority in this case to change that order, that this is set for entry of a parenting plan as soon as this expires. And that's assuming that there's not a request for it to be reissued or any issues that way. The other thing is that Miss Amaskita can always petition to have that protection order amended to allow for, because right now all it allows for is supervised visitation and electronic communication.
Right. May I say something, Your Honor?
You can.
So the whole point in the protection order isn't really revolved around Miss Amaskita. It's revolved around the person that showed signs of abuse towards my son. So the supervised visitation is really to try and protect him from Miss Amaskita's boyfriend that had left marks on his arms and repeatedly showed abuse signs. So the only reason for the supervised visitation really is just to keep him away from Chaddock, because Chaddock resides in the home. And that is something my son has been very vocal about, even in the supervised visitations. That was a part of the statement that you can't read very well. It was written in handwriting, and the copies kind of blurred it out. That was kind of a statement from my mother, the one that was originally doing the supervised visitations. And in the statement, it had stated that he was very vocal about being scared to go see his mom as long as Mike was around. So my only worry is him going back and having any sort of contact with somebody that has abused him, that has showed signs that he is scared of being over there. He's gone through quite a few different routes in school for therapy. He has been doing well in school, but the one thing he's been very vocal about is going back to that house and being around just that one person. His mom is not the issue in this case at all.
Okay. Miss Amaskita, you wanted to say something as well?
Yeah. When I go see my son, it's been difficult because of Mr. Miller's mom dropping on me that she started working and I had to figure it out. So I had to go with his grandparents, and they let me see him when they have him. And I've asked for more days to visit, but he told me he can't because he's working all the time and I don't have a way to see him. I tried calling before, but I just gave up on trying to call, except when he's at the grandparents' house because of his work schedule. And then Mike's been going to the court-ordered DV classes. I don't know, has Mr. Miller been going to the court-ordered DV classes? Because I would like to know if he started those or not. Because I don't, Mike's been going for quite a few months now. And when I go see my son, he doesn't even bring up Mike's name at all. Like, when I saw him Christmas Eve, he doesn't even remember who Mike is. Like, he never mentions him when I'm around. And when I got his report card, it was kind of bad because it showed all ones, and his grandma didn't even get his report card till I showed her. And like, I've discussed school with his grandma and some other stuff that's concerning because his behavior is still, he still acts out. If he's not like taking his medicine, because when I went up there Christmas Eve, he was very acting up, like, just, you could tell he was like not on medicine, because normally when he takes his medicine, he's calm and very attentive, but he was all over the place and was just like a wild. And he doesn't listen to me. Like, when I try to talk to him, like when I'm trying to have a conversation with him, he won't pay attention to me. So like, I feel like I can't really try to communicate with him that well when I try to talk to him, my son. And I feel like I have no say when I'm trying to talk to him, because like the grandparents always like say stuff for him, or like I feel like I can't tell him stuff, or I'll get like judged, or like his grandparents, because of the way he was acting, told me to spank him, and I told him I'm not touching him. I don't want to spank him. I don't want to get that thrown at me and thrown under the bus, because I just feel like I can't do anything with my son, or they're just going to write statements about me saying I'm a bad person. So I just kind of feel like I'm in a bad spot right now. Whenever I try to see my son, I feel like I have to like walk on eggshells, because pretty much they can say whatever they want about me. And like, I really want to see my son, but I like have no help. Anytime they offer for me to see him on extra days, I don't have daycare. I don't have childcare. I have no family to watch my other two kids. And I've told that to his grandparents, and they're like, oh well. So it's been kind of difficult for me.
May I say something, Your Honor? May I respond?
Yes, let me
Okay.
respond first. So I appreciate that, Ms. Amaskita, and I understand the difficulty here, and I'm going to address hopefully some of those concerns today. I don't know that we can address everything today, but I appreciate your comments. Mr. Miller, go ahead.
Okay. First off, my grandparents are, when they do have him, she is available any day to go up unless they're out of town or something. But the whole reason they took over custody was because Miss Amaskita had stated to my mother, the one doing the supervised visitation before, that the only day she had available was Friday. And it was at 4 to 5 o'clock, and she would leave by 6. She only took 2 hours to see her son. When she was up at my grandparents', they had told me a little bit about her visitations, that she was playing on her phone the whole time. They basically watched all the kids, including her own two that she had brought over. That the last time she had visited, she asked if she could have the Wi-Fi password so she could just play on her phone instead of having interaction with her son. And my grandfather had told her that he wanted her to interact with her son more rather than play on her phone, and instead went and laid on my grandparents' couch and took a nap. Now, I understand she's a mom. I know it gets hard, but only taking 2 hours a week to see her son when you have available 8, she has not reached out, and they have encouraged her to try and see her son more. She has made the statement that either she's busy or she's working. And she's only said the only day she can do is Friday for 1 to 2 hours. That is all she's taken upon. The last 2 months, she has not tried to call her son. And to me, it seems that she doesn't want to have it. When she does see her son, she's not having interaction with him. Instead, my grandparents basically are watching all the kids the whole time. As for the spanking comment, I don't believe that for a second. I don't believe that's a true statement. They wouldn't say something like that. So my grandparents, they took over to make sure that she could still see her son. They are retired. They do not have jobs. And if she called ahead of time and let them know, hey, I want to see him more days, she is more than welcome to take up the available 8 hours a week that she has available, but she has not taken up that opportunity.
All right. Well, I'm not concerned. I think if you were in the same situation with your work schedule, it would be hard to navigate 8 hours of visitation a week.
Right.
So I think we have to be honest and occasionally look at the situation from the perspective of the other party. Miss Amiskita is kind of in I think you're pretty well aware, as is the court, of her familial history and what she's dealing with there, not to mention these, what's going on in this case. So I appreciate that. And I'm sure your child wants to spend more time with mom, and I'm sure mom wants to spend more time with child.
Yes.
Being under the purview, if you were being supervised by only her family, it probably would be uncomfortable, even over an extended period of time. Even though I know, and my recollection is that you both have been a part of each other's life for a substantial period of time, and even when you were teenagers, and so I understand she's close with your family, but it's still, I'm sure she feels like she's under the microscope. So I'm not really concerned about the timing of all this. It's got to be hard to navigate. Miss Amiskita, I would hope, would take as much time as she could get, because we're still sort of under the same order that we've been under. So up to 8 hours a week of visitation.
I just wanted to make the court aware that she does have access to more time. Seems that, she's stating that they're denying her access. They are not denying her access. She can take any time she wants. She just needs to let them know ahead of time.
Okay. I'm looking at and I'm going to ask, so I know, Mr. Miller, you did submit your evaluation as ordered by the court, your DV evaluation. It does suggest 9 months of treatment with one class a week. Have you been following through with that?
That I did call the place. They had no available spots. I know pertaining the case with them bringing up the assault charge and the trespassing, I was found innocent on all charges. Did those go to trial? That was something that happened post. Okay.
Yes.
Right. And I was found innocent on all charges. Their stories did not line up. I don't believe there's a need really for me to go. I just feel like I'm kind of being targeted. I get they're the opposing side. They're going to try and dig dirt on me, but I just don't see the reasoning behind it. I feel I have no restraining orders on me saying I'm abusive. I've never been arrested for abuse, nothing like that. So I don't really understand the findings of having to take 9 months of DV evaluations.
You weren't ordered. You were ordered to do the evaluation. I was just inquiring whether you followed through with the suggestion in the evaluation for treatment.
Okay, thank you, Your Honor.
And it sounds like, Miss Amiskita, you're indicating that Mr. Chaddock has followed through with, I think he was, it was a 6 months of treatment is what he was, what was suggested in his evaluation, and he has been doing that. Is that what you're?
Yeah, because we were under the assumption that everything was court ordered, so he did it to follow the order.
Okay. It was ordered, the evaluation was ordered, and to provide the results, there wasn't a direct order to follow through with the recommended treatment. Given, I think it's appropriate that he did that, and I think that's a good thing that he did that. Well, here's here's where we're at. So with this, the more I look at the protection order, and it sounds like potentially Mr. Miller may be agreeable to this, but Miss Amaskita, with this order in place, if I enter a parenting plan, it's really not going to do any good until March 6th. Because this specifically prohibits you from having direct contact that's not supervised with your child. So if I were to change the parenting plan at this point, it could, you know, arguably could set you up for a violation. And I don't know if Mr. Miller is willing to, if you were to file a motion to amend the protection order that's currently in place for the next 3 months approximately, to allow for unsupervised visitation, then we could move forward in getting a kind of a more stabilized parenting plan in place. I understand that Mr. Miller still has reservations about Mr. Chaddock, and the order that at this point is that any visitation that Mr. Chaddock not be a part of that, and that would remain in place, because that's in the parenting plan case, not in the protection order case, and would allow you to just have your child go on an outing, do what you wanted to do without Mr. Chaddock, and just have some one-on-one time with your child. But given where we're at, I'm not going to do that because I don't want to set you up for a violation in that other cause number. So I can't give legal advice. I'm suggesting that maybe you speak with Mr. Miller about what he's comfortable with until that order is gone, as far as like maybe amending it to allow for contact with the child as long as Mr. Chaddock isn't present. Otherwise, my best suggestion, given the status of this case and that all protection orders besides this final one have now lapsed, would be to set this for review on March 6, 2024 at 9 a.m. for entry of a parenting plan, because that would be the date that the protection order exhausts itself.
Can I ask something?
Mm-hmm.
So I know, like, when I tried to fight it, the judge or commissioner didn't really want to listen to me because
Are you talking about the protection order?
Yeah, for the protection order I had.
All right.
So I didn't think there was a reason to try to fight it because I didn't have an attorney to help me with it. And I can't afford an attorney to help me fight it. And if I was to do that, like, what if he decides to go put another protection order on me or Mike? Like, I can't stop him from doing that. And then I can't stop him from, like, having his family say more stuff about me. Like, I'm kind of at a, like, I don't really know what to do because, like, I feel like anything I do, even if I, like, fight the protection order and get, like, able to see my son, I feel like he'll just go around and start saying stuff again and have even more problems in the future. I just don't know what to do.
Well, I can't give legal advice. What I would suggest, however, is that you get some kind of if you're allowed to, the protection order allows you to talk to, hold on, let me just bring this up again because I don't want to misquote it, but it allows for electronic communications between the adults regarding the welfare and visitation of the child. So that says via a family app. Do you guys have Our Family Wizard, or is it Our
I
Family
still
Wizard?
have it.
Okay.
I don't know when it comes out again because I don't know when it comes out of my account for paying it.
Okay, you should be able to do the free version for at least message exchanges. The paid version is has calendaring and all that other stuff. But the protection order allows electronic communication in the family app for welfare and visitation. What I'd like to see, and is an attempt at communicating to schedule sort of a regular visitation while this protection order is pending, and make and see if because I'm not going to negotiate this in open court on YouTube, but I would like to see if there can be maybe an agreement on how to move forward. My thoughts and my hope is that Mr. Miller wants you to be a part of your child's life. I do. But it's just a matter of how we can make that happen and alleviate the concerns he has about your current partner. And maybe showing him what your current partner is doing as part of that evaluation would be helpful to him. That he's taken that seriously and has taken steps to address those concerns. But I think what I am going to do. So Kaylee, if we could set this, and I hate that there's not a conclusion for you folks, because I think that would be really in your best interest. But I don't, as I already explained, I don't want to enter a parenting plan now that isn't going to work. So I'm going to set this to March 6th, 2024, 9:00 a.m. That's the pro se docket. So that's a docket specifically for folks that don't have attorneys. Okay. You can, Miss Amiskita on Mondays and Mr. Miller on Mondays at the Hall of Justice here in Cowles County on the second floor. And I think they're not starting back up until maybe the 22nd of January. I'm not entirely sure. So I think the 15th, is it 22nd?
Yes.
Thank you, Kaylee. The 22nd of January, I think, is they're starting back up from noon to 2 p.m. There are attorneys that are that help people that need information about how to do paperwork or what they can do and not do. So I encourage you to come to the Hall of Justice on a Monday and see if you can meet with one of those individuals and get maybe the legal advice I can't give you in this case, to see how you can be prepared for a plan that everyone can work with, that hopefully can get entered in March. That makes sense?
Yeah.
Okay. And if there's an agreement to amend that protection order, and you file something, on the protection order docket to do that, and if there's an agreed parenting plan that the two of you can be comfortable with, you can always enter it sooner than that. Okay. But I encourage you to reach out to the attorneys that are volunteering on our and Miss Amiskita, they can talk to you about the protection order portion as well. So it's not just a family law. They do kind of all sorts of different things. So and it's starting back up on Monday the 22nd. Okay.
Okay.
And then we'll set a review for March 6th, 9 a.m. That's going to be the pro se family law docket.
Okay.
And my hope is that we have a proposed parenting plan at that point, and both of you can file your own proposed parenting plan, and we can kind of move forward from and get some kind of consistency in visitations for this young man.
What day again?
Wednesday, March 6th, 2024, 9:00 a.m.
Okay.
And like I said, if something happens with the protection order prior to that and there's an agreement, you can always move that date up.
Okay.
Okay.
All right.
All right. Please communicate via that app to try to get some stuff set up. And Miss Amiskita, please utilize as much visitation as you can. It's important to keep that connection. That being said, I know your concerns and I know your frustrations, and I appreciate Mr. Miller's as well. So, all right.
All right. Thank you, Your Honor.
Good luck to you both. Thank you.
Bye.